All right, I've pressed mute, so if you want to press *6 to unmute to speak. So we'll get started here. Welcome, everyone, to this Tuesday, February 16th meeting of Money, Banking, and Trust. I'm your host, Christian Walters. And again, this will be more of a question and answer period. So I don't really have anything specific to talk about tonight, so I was kind of watching the Olympics. But anyway, yeah, we might as well just open up for Q&A. So press *6, state your name, where you're from, and we'll take some questions.
Christian, this is Floyd from Virginia.
Floyd, how are you?
I'm fine. I do have a question on bringing the private or announcing the private to the public. And I was wondering, is the only way that you can do that is through the UCC-1?
We're looking to create a public record, so if there's another way of creating a public record, different ways, you could publicize something in the newspaper for 3 consecutive weeks and use those publications as, notice.
Uh-huh.
What we're trying to do is create a record that's outside the hearsay rule that could be put into court without any to the hearsay rules. So I would look under your federal rules of evidence or your state local evidence and go through those and see what's going to comport to what you need. Usually a public record is outside the hearing, or a presentment by a notary is the exception because it's a self-authenticating document. So anything that creates a public record is what we're looking for. UCC-1, UCC, county recording, something like that.
Okay, so a notary public is really is a way of putting it into the public. Then is that correct?
Yeah. Well, the notary public's got to do, say, the presentment, but then the recording of that on a UCC-1 or a county recording of a notice of the existence of, say, your private document of the notary.
Okay, what about an affidavit? When you create an affidavit, then do you get that notarized?
Yeah, if you did an affidavit, you could notarize the affidavit. It's not a public document. You need to give a notice that something exists, that affidavit, and then again you put it on a UCC-1 or a county recording, a notice of it.
Oh, okay, I see that. Okay. In regard to your, I sent you an email, and I wanted to kind of keep that between you and me, and I was just wondering, my email is Floyd_Howe@yahoo.com, and I was wondering if you could answer me on that email in regard to the your workshop.
Yeah, I really haven't announced the workshop start date yet, but it's coming up here shortly.
Yeah.
Did you respond to like TT registration and ask for a registration for application and registration?
Yeah, I did that, and I also asked you a question in there, and I wanted to have that question answered as to joining. So I was wondering if you could answer me on that.
It was a specific question for joining the.
Yeah, it was a question on pay.
Oh, okay, all right. Well, I haven't read the email, so I don't know.
Okay.
I'm behind on my emails.
Yeah, well, I was wondering if that might be the case, because I know that other people they said that they had sent in an email to you and they got an answer quite quickly. So anyway, I sent it in just the other day, so I didn't expect to get an answer back right away. I know you're busy.
Yeah, for the last week and a half, 2 weeks, I've been so slow on emails. I haven't even really checked my emails hardly at all.
Uh-huh.
I was too busy. Website set up and got the audios up there on the website. That was the main focus first. So
Yeah.
So
Okay.
I'll be able
Well.
to check on some emails.
Yeah. Okay.
And thank you for that, Christian.
That's quite okay. You're welcome.
The website, you mean?
Affirmative on the audios.
Yeah. Okay. I've got last Saturday's to put up there yet, and I've got probably tonight's, and I was missing one from the week before, so I have to do some audio adjustments on that and then set it up there. So that should be up here probably in the next day or so. Anybody else have any other questions there for you?
Well, I probably will have some more questions later on, but that was the only thing that I was kind of wondering about, because if you have to put whatever you're doing on a UCC1, that could either be pretty laborious or even get quite expensive sometimes. That was
that's why I recommend filing electronically online. It's only like $5.
Oh, you file a UCC1 online?
Yes, electronically. I know in Kentucky it's only like $5.
Oh, how? Okay, I guess I don't know how to do that. What do you just?
Yeah, get on the internet and go to your Secretary of State and check out where they file the UCCs, and they'll have their price schedule for electronic filing.
Oh, I see. Okay. That'll make it easy.
Do electronic filing. I know Florida does not do electronic filing, but a good portion of the states do, and they have different prices. So,
all right. Well, that's good to know. Well, I'll have a question. Maybe something will come to my mind later on. But right now, that was my biggest question for the moment, anyway.
Okay.
Hello, Christian.
Hey, who is this?
Hey, 3 guesses, and the first 2 don't count.
All right.
Never mind.
Good to hear from you, my friend.
Well, thank you, my friend. You're a great guy, and I just want to get a little clarification on an old subject, because I was reviewing some audios from October and November, and in those concerning the A for B in a debtor-creditor relationship, you had said to use the word grantor as on the top page, and then in the December program, you said not to use the word grantor in a creditor-debtor situation. So just for clarification, for those of us who already got the debtor-creditor things out there, tell us again one more time, if you were going to go implement your your A for B in the debtor-creditor situation, would you use grantor or not?
Yeah, I wouldn't do anything from this point on without putting some kind of qualifier on there as being, say, by grantor.
You would use the word grantor.
Yeah, I would use the word grantor in there, by grantor, and then my signature. Yeah.
Oh, well, very good. That's great.
You can get away with using my signature by grantor in there if they wouldn't open up an account or something like that. I would use ... 3 dots before my name, and then I would sign my signature. And those 3 dots signifies under UCC that you have really an incomplete instrument under 3-115. There's an additional word.
So you're going to write by ... your name, or you're going to write by grantor ...
I'm just going to put ... I'll put 3 dots and then my signature.
Oh, you're not going to use the word grantor then?
Well, no, I'm not. I would try to get the word by grantor in there, but in some kind of situations, maybe they would reject your signature if you wanted to say open up in a bank account or something.
Right. Okay, I got you. They tried that with me on
get that.
passport.
Well, I make something that's so simpler that they may not even say anything about that dot, which signifies there's something missing, and then my signature.
Excellent. And then you can say whatever you want to that it is later on.
Correct. That's demonstrating my intent by the 3 dots, that there's something missing, and what's missing is by grantor.
Okay, thank you.
I will try to sign by grantor.
I'm sorry, did you break out? Did you go away?
No, I was saying that I would first try to sign by grantor and then my signature.
Yeah, right. Okay, I got it. Now, for clarification on one other item, is authorized representative always a trustee?
No, not really. If could be an authorized representative of the beneficiary.
Well, that's what I was thinking. Somebody was trying to tell me, no, Christian said that authorized representative and trustee are the same. I said, well, they can be the same in certain cases, but trustee is always a trustee. Authorized representative can be different things.
Yeah, he's just more or less an agent for whoever. And if the whoever is trustee, well, he's authorized agent for the trustee or authorized rep.
Exactly. So on the back where you endorse, instead of trustee, you can say authorized representative, and you can say, well, I meant authorized representative. In that case, is the trustee. Would that be correct or incorrect?
Say that again? On the back with what?
Where you endorse, like you would a check, oftentimes you say to sign that as a trustee because the trustee is liable and the trustee has the money. But like I've got a stamp that's already made that says authorized representative on it. So
well, as long as you can prove that you're the authorized representative for the trustee, then yeah.
Oh, you would have to prove that you're the authorized representative for the trustee?
They may ask you, yeah. They may have to have you prove that who you say you are.
Well, how would you do that?
Well, I could have a Form 56 appointed by the grantor that I am, say, authorized to operate with the trustee, or a Form 56 from the trustee, or maybe even a power of attorney, say, for the beneficiary.
Okay. Does a
power of attorney the trustee.
Go ahead and enlarge on that.
Yeah, well, that'll give me the authority to do whatever is spelled out in the duty that trustee is going to give me, or that beneficiary right's going to give me. You know, whatever right's going to be assigned, I'm allowed to do, whatever authority.
Now, the Form 56, is it possible to have multiple Form 56s filed that say different things, or is it always the last one that you filed takes precedence over the previous ones?
If it's on the same account for the same person, it would probably be the last one filed would take precedence.
Right.
Unless it's an appointment with some other, you know.
But if the Form 56 is written by the trustee, that would be different than the Form 56 written by the grantor.
Right, because it's two different parties given different authorities.
Even
the
though
beneficiary's got his rights assigned, and trustee has his rights that he couldn't assign.
Excellent. Well, I'm catching up a little bit. Now, if we can fast forward up to the chambers, I don't want to say Star Chamber event, but in the private meeting, and where I'm not making the connection is when you're talking about merging the titles, the equitable title and the collectible title, or what do you call it, the equitable title and the help me out here.
Legal title and beneficial title.
So you got a legal title and a beneficial title, and you're telling this judge that as the grantor, you designated him to be the trustee. If he doesn't want to be, then you have a short list of who you would recommend. Something like that? Does that work?
That's not up to me. I mean, if I appointed the judge, say the trustee, then he is going to be the one who's going to be, if he disclaims, a resulting trust is going to form in court there, and then he's got the responsibility and duty to appoint a trustee and not allow the trust to fail for a lack of a trustee.
Okay, so in that moment in time, a trust is formed. Is that what you're saying, or some step further back?
Resulting trust is formed, yeah.
Okay,
yeah.
resulting
and
trust
the
is formed.
title act as temporary trustee until the new successor can be appointed by the judge.
Now, of course, the judge is going to say, well, you need to prove your trust, and then you're going to name the parties, and you're going to name the purpose and the intent and the res. I can be basic, but if I can repeat it, it'd sound better.
Repeat what now?
I hate to repeat myself and sound so basic, but you got four elements that trust is owned from. And so the res is going to be the property. Is that correct? In a foreclosure case?
The case itself.
The case itself is the property. Did you have to accept that for value, or you just say it?
No, I don't have. No. That's under debtor creditor stuff. I don't have to.
Okay. All right. So you're in the court chamber, or you're in the chambers, and you said that here's a trust, and this case is the property. And I'm the grantor, and who's the beneficiary? Yourself?
You want to straight and point it, but I would point myself beneficiary.
Sure. And then there's the trustee, and the judge says, "We'll prove it," and so you pull out your proof, which is a public notice of your SS5 application.
Well, I wouldn't have to prove that. I would just have to prove that case was trust. That case, that trust property had been transferred to the trustee, and at that point, that's when the trust formed. So I would need the two records to prove the claiming and two records to prove the transfer whenever the present transfer took place.
Now, the transfer can be done by contract or by delivery or by the two other methods. Help me out.
Well, not so much by contract, although be a declaration within the grantor, as grantor as being also trustee. He could do it by declaration, outward declaration. Then transfer under 2 would be 4 subheadings, which we said endorsement, delivery, and the third one is assignment on a UCC3, and by law, delivery and assignment on a UCC3, which is really all 3 are transfer, come under the heading transfer.
Okay, so the best way to perfect your transfer and demonstrate by your proof or notice of record of the declaration.
But it's a declaration on a particular kind of application where the grantor is the trustee also. So there's a present transfer within yourself, and how you could express that would be by declaration, because nobody would know, as me being grantor and trustee, that I transferred trust property within myself. So I have to make a declaration that that happened. Right, and you would have a notice of that declaration. Right, but now if I was grantor and beneficiary, I would not use a declaration. All right, what would you use? I would have transfer. And what method of transfer? About when is trust property transferring, and who's it transferring from, and to whom? Because if the grantor was also the trustee within himself, there's no way of proving that there was a present transfer. But one of the ways you could use would be by declaration. So you would make a public declaration. But now if the grantor was also
another scenario, grantor was the beneficiary. So you're not transferring within yourself. So a declaration, I would use a transfer method under the endorsement, delivery, and assignment.
And so the proof of that would that be in the UCC one?
Yeah, those are the two records that would prove, say, a present transfer that happened, say, 3 years prior. It didn't happen right then when you're registering the UCC one. It doesn't happen then. The trust was not formed at that point. It was formed 3 years prior.
All right, I'm getting confused now because before you said the trust was the case. Was the trust.
You broke now. Sorry, did you catch that last part?
Well, you said earlier that the court case was the trust. So how could that be 3 years prior? Because it didn't happen to us.
Well, I'll just give an example. Let's just say it was a mortgage that transferred at the mortgage closing. And that was, say, 3 years prior.
Yes. So that was that trust. But it sounds like the court case itself is another trust, or trust relationship.
Because you incorporate the mortgage foreclosure, that closing, into this case. Depends how you want to treat it. It could be all one, or you could treat it as two separate ones.
What do you feel is the most advantageous for the homeowner?
Wrap them all up in one, just use the case.
Okay, so how are you going to say that the trust occurred 3 years ago if the case was only 2 months old?
So that's where the present transfer actually occurred, which was, when did it happen? Well, it happened at closing. I gave the note to the escrow agents. So that's when the present transfer occurred on that trust.
On that trust. Now, the trust that the judge is asking you to prove in the chambers, he's asking you to prove the one in the case and the one in closing, or just the one in closing?
Depends which one you want to bring forward. If you incorporate them all in the case, then, I could go for just the case being transferred and prove it just, that was open shortly after that.
Well, I don't want to take up the whole show.
Yeah, there's some confusions on, when the trust is, when the trust is really formed. And that's when the trust res transfers. And there's some question about, what is the trust? Some people are having difficulty, it just depends which four elements want to play it.
Yeah, that's at least my understanding is the trust is the 4 elements. It's the relationship that when you're talking about 3 years ago, then that's one trust back there, and carried forward to the case, that's another trust.
Carried back to the signature, because where the signatures were signed, that's when the trust came about. When you put your name on a piece of paper, but now you might want to combine 2 trusts into one and treat them as one. I don't know how you want to play it. Or you could treat each one separate.
Let's do it the simplest way for us beginners. The simplest way to handle it and explain it and to keep it in our mind.
Hey, Christian. Christian, this is Bill. This is Bill from Michigan. Chris and I have been talking about this, and we're working with some other people. Do you mind if I butt in here? Because I want to paint a picture to try and help this gentleman a little bit, if you don't mind. May I, please?
Absolutely.
If I'm off base on this, please cut me off. Let's just take a typical court case. So you're in a situation, and because Christian, we've been getting some data on this, data points and feedback from the field on people that are actually doing this. Let's just take a typical court case, and a lady or gentleman is summoned to show up. And prior to going in, we put a notice in clarifying that a trust exists with the court, and that you're claiming the trustee position. Now, when you go into that courtroom and they call your name and you stand up and you say, ready, Your Honor, I'm the trustee here on this matter. Okay? Now, if we go back to the training and the explanation that you so eloquently have been able to draw out of this great book, which is not super easy to understand, and obviously you spent a lot of time on Gilbert's. When you walk in there, you're walking into that courtroom as a trustee, implied as a protectionary trust. Now, as soon as you say your name, there's a conversion that goes on. If you do not claim trustee position and express it as a trust with substance and form, that a conversion takes place from the protectionary trust to a discretionary trust, at which point the judge automatically assumes the role of the trustee. Now, what is your position in the equation? I'm asking you a question. What is your position in the equation once that conversion takes place from a protectionary to a discretionary trust? If you're one of the parties in the equation, which party are you?
Well, I would want to be, in a court case, I would want to be the beneficiary, so no matter which way they misconstrued it, I would come in there with the correction and make myself the beneficiary.
Okay, now let me ask you a question. Do beneficiaries have standing in a courtroom?
They have to come through the trustees, but they're the only ones who can do the claim against the trustee for a breach. Now, if the trustee is doing the breach, then how can they come through the trustee?
This is true. This is true. So you can take it from either perspective. If you claim
the one trustee won't claim, then the beneficiary has the right to come in and do the claim himself.
But are you pushing mud uphill as the beneficiary, or can you control the case and strip the judge of his rights by maintaining the position as trustee? Because this is what we're seeing in the field. When the people are going in expressing with notice to the court that they are the trustee in the matter, and then they demonstrate that in form in the courtroom, the judges are flipping out because beneficiaries have no standing. And this is the problem that we've been seeing all along in all these court cases. People go in there and they say their name, and then all of a sudden, bam, the court can't recognize them. Why? Because the beneficiary has no standing. They are not in there as a corporate capacity.
That's where you want to get into chamber, because that's where the beneficiary does have standing.
Okay, but what happens when the court hammers? So you're saying we just accept it, and I was at a weekend retreat this past weekend, and I brought up this thing about the in camera. Now, do you have any first-hand evidence of that being tried, whereby it's been successful?
Well, we've got several people trying it now, so shortly we should have some results.
Some data points?
Right.
Okay. I'm not challenging anything you're saying, because I think you have done a tremendous job, and I've enunciated that on more than one occasion. I'm trying to get my head around this thing from what's going on from a fundamental standpoint. And what you're saying is maintain the position as beneficiary, accept whatever charges they give you, and say we're going to settle it, go in, and then flip it around on them with the private instrument. That's
there's two ways of playing that scenario, right? And then the other way is you could still maintain trusteeship, but then you just come into court in chambers again and say, I'm going to admit, outside the court, that I am the trustee. I'm going to admit that I did not make the payment. So now there's no controversy, but now we still have to go into chambers because I have another reason why. I have a legal reason that I didn't make the payment. I tell you that now because that's the secret stuff, the state secret, and that's what I would have to be presenting in chambers. In chambers, that would be because the discretionary trust, like brought up earlier, it was per the discretion of the trustee not to make the payment, and that's his lawful stance, because it would be in violation of the trust purpose, which was not to disperse the funds to the beneficiary because the creditors were after his asset because he was insolvent.
Right.
So there's two scenarios you can play there.
Right.
Depends which position you understand a little bit better and which way you feel more confidence to say defend.
Well, one of the things that we've been seeing, and you've already expressed it because I've seen some of the work that you and Chris have worked on in terms of the basic trust expression, and the result of that seems to be pretty phenomenal. And I'm getting independent data points from other guys that are seeing the exact same results. It puts the court in a bind because what's going on, you got this duality of positions and roles that the judge is going to play, whereby, yes, I'm the trustee, he says, I'm the trustee in this manner, but you're in breach of trust. So, therefore, I'm going to dictate to you. But as soon as we express trust and claim position of trustee, the duality, I believe, goes away. And Rob, my other associate is on right now. I don't know if you want to pipe in and comment on that.
You've really straightened out construment, how the court is construing it, because there was no real expression of the trust.
Right.
The grantor is the only one who can, demonstrate his intent or his purpose.
Right.
If it was not in writing.
Mm-hmm. Now here's the
forward.
Go ahead.
The court has to take his word for what he says because he's the grantor. He's telling the court, what his intent and what his purpose was.
Right. Now, one of the things that we keep talking about the four elements, because I brought that up at our retreat this past weekend, and the guy that was the speaker, I asked him, I said, so is it true that if we claim position as express trust, and is it true that we need to prove trust? And he kind of looked at me cross-eyed. He didn't know what I was saying. And he says, well,
right.
He says, what we've been doing is all we've had to do was produce the birth certificate. And bam, everything changed. Because what have you got? You've got the decedent that's on the birth certificate. That's one of the parties, right?
Right.
And then you've got the grantor, which is the man / trustee, and then you've got what? The court, the beneficiary. But really the dead guy is also a beneficiary. So this birth certificate...
I think we have to get in a better position to where we can prove trust, as to exact parties having the records and making sure that we know what we're doing on that.
I agree. I agree. And I'm not negating anything that you're saying. I'm just curious as to whether or not the courts are, for lack of a better term, as anal about it as we are, because we're really hammering this stuff home. But I don't know if they're going to scrutinize it the way we would scrutinize it. At least we've got our ducks in a row. That's what you're saying.
Yeah, probably later on it's a little more tighter, and they're going to demand that you prove the trust, with exact records, and you're going to have to know and back that up yourself.
As this thing starts to
right now, you're throwing them in a tizzy. We're throwing them in a tizzy, and they just don't know how quite to handle it.
Mm-hmm. Right, and that's what we've been seeing too from the field. So, well, I appreciate you letting me pipe up here. I hope that was helpful for the other gentleman.
Christian? Hello, Christian?
Dave again?
Yeah, well, with respect to... Hello, Christian?
Yes, I'm here. Go ahead.
Yeah, with respect to Bill's comment, form a nominee trust where the beneficiary direct the trustee, would that help us out?
A nominee trust, and do what again?
Okay, it says in blacks, it says nominee trust. A trust in which the beneficiary has the power to direct the trustee's actions regarding the trust property. So if that was the case that we were talking about, the beneficiary, even though it became the new trustee, the beneficiary could then at that point still direct the trustee under nominee trust.
Yeah, if there's multiple beneficiaries, they'd have to all be in agreement, but if it's just one, yeah, the beneficiary can be the one. Especially if it was written in the indenture or specified by the grantor that the power still remains.
Right, that's what I'm leading to, because if what he's saying is true, that the titles of the beneficiary will be shifting, we would put in advance that we're making a nominee trust where the one beneficiary, if you're in court, you personally, you have that power by the indenture of the trust.
Yes, because if I were expressing the trust and put it on there minimally that I had the power to revoke and modify, that's about all I would really need to get in there and say, I can change anything around the way I wanted it to. Kind of worded it broadly so that you could, interpret it any way that you wanted, come back in, and if it was misconstrued in any way, you could come back in and correct it.
So are you saying it's best to be generally vague or, specifically on target?
The more specific wording you put in there, the more tighter the rope you're going to be walking, and you have less wiggle room. Mm-hmm. So I kind of like once I put in there, I know specifically what I'm going to put down. I like the loose wording, really, because that leaves me to, shoot from the hip.
So then you would be construing the trust.
I would be correcting the misconstruement, right?
Okay, yeah. And that would be based upon the fact that you would be the grantor.
Yeah, right.
Cool. All right. Oh, yes. And back to that, your comment about electronic filing. When we do that electronically, we file the UCC-1, do we have a hard copy documentation available?
Yeah, I think you can order a copy, usually a certified copy. But then you can also copy off of your internet, so that's, you've got some kind of a record there.
So if that's the case, then wouldn't that, in those states that have electronic filings, that would solve a lot of problems with getting into the court, to the county recorder's office, right?
Yeah, and then after a copy, and then about 10, 14 days, you get that. Then you got a hard copy printed off the internet. You got that.
Oh, so the county sends you one anyway?
Well, there's where I put the notice in separately from the UCC filing.
No, I'm talking about electronically.
Well, not so much electronically on the county, just with the state on the UCC.
Right. So then the state would send me a copy, a hard copy, or I can just download it. That's what I can get.
Have a record downloaded from the printing filing that I did online, but then I would also request a hard copy, a certified copy from them. So 10, 15 days later, I'm going to get that.
And then when I file it with the county as well?
Yeah, then I'll file a notice into the county.
Okay, cool.
Thank you. So I'm creating two records. I got my two witnesses, two records.
Right.
Coach Jay?
Hey, Jay?
Yeah, if the property is jointly owned by husband and wife, and the wife has a lot more on the ball than the husband in this regard, should the husband just kind of stay on the sidelines as a grantor, having given her the duty as beneficiary, or the benefit of beneficiary?
Yeah, that's fine. grantor and she's beneficiary, right?
Yeah, okay. So she basically tells the trustee that what he needs to do is take care of this.
Correct.
Thank you.
Christian?
Did we answer your other question before?
Pretty much. I got a lot further along tonight than I was before I got on the call, so I can only take so much, you know.
Where you been? You been kind of busy or what?
I have been busy, and listen, there's a lot of... It took you how many thousand hours to get where you're at?
Well, I got a lot of hours, let's put it that way.
Yeah. Well, you know, we're running to catch up, but we're still far behind. So be patient, and we'll get there.
Have your back ones there? Have you gone over some of the back ones to catch up? Is that...
Oh, of course. I am. I've even got them transcribed and read them, but, you know, you have to work that job, too, so it's not a full-time profession yet. But we are in a foreclosure situation. You have to push it in before you put it down. But after it's down, then it won't move in.
Good, Christian. No, Christian?
Okay. Are you done, Dave?
Yes, go ahead. Let somebody else talk, please.
Okay. Who's this now?
Hi, Christian. How you doing? This is Dominic from Ireland.
Dominic. Oh, good. How are you?
I'm good. How are you doing?
Not too bad. Trying to watch the Olympics.
Oh, cool. Nice one. I have a question. I'm a sort of newbie to trust technology, but I just wanted to ask you a question and get it small but specific about a certain situation I'm going through. I did a private administration procedure, I suppose you could say under debtor creditor, on an unsecured loan here in Ireland with a particular lending institution. It was condensed into a pretty kind of short 3-step procedure, and now I'm at the stage where they've got they're in dishonor, I suppose, and non-response. But before I initiated the process with them, Christian, I issued them a fee schedule, and I placed a certain fee on there for commercial dishonor. Now, I haven't expressed in any form of trust in my wordings to date in any of the documentations I've sent them. But what I plan to do is, and this is where I'd like your feedback on, is here's I suppose what I want to propose to do with this is, I want to issue them a certificate of dishonor and non-response notarized here by a public official, and get the postal service to stamp it as well, to stamp a certified copy, send it off to them. I want to put the value of this dishonor that I've placed on the fee schedule on this particular certificate of dishonor, and any other outstanding amounts I might have from various invoices to them on this certificate, and express the trust via signing it as grantor and send it off to them. Now, I would have also done a non-UCC on this document too. I want to proceed with this using trust technology. What do you think the best way to finish this process off would be, or how would you complete the process from here?
Treat that as the trust res, the administrative remedy that you're working on.
The certificate of dishonor, is it?
Yeah, just the dishonor, yeah.
Okay.
Treat that as trust res and give that to the trustee in expressing the trust, and create those records that he's got to be able to prove along with one of the methods of formation, so that you got a trust.
Okay. Now, proving the trust is, are you talking like, I would have a color copy directly from this lending institution of the agreement form, would, obviously with my signature on it. Would this constitute, proof of trust?
Well, remember, the trust is really the trust res in relationship to a trustee with duties for a third party, a beneficiary. So when did the trust res transfer to the trustee?
About a year, about 2 years ago.
Okay, but you're saying you're going to treat this administrative process as being the trust property, right?
Correct, yeah, the certificate of dishonor. Sorry, Christian, yeah.
Okay, so when did that happen?
It hasn't happened yet. It's about to happen in the next couple of days.
Okay, so when that happens, then you want to transfer that to whoever's going to be the trustee, and who would your trustee be?
It would be probably the CFO of the institution.
Okay, so the institution was the one who sent you the offer?
Correct.
Okay. Yeah, because the person who sends the offer would be the one I would appoint as the trustee.
Okay.
Now, you've got to create some records of when the transfer takes place, because that's when the trust was going to be forming.
Okay, so the trust is basically formed.
Once you got honor and you got straight remedy all done, then you're going to treat that as trust res property, and you're going to transfer it as a present transfer and create the records that was done, which the records are going to be public notification that, hey, I got a trust here. So once you send it to them and you've got the, say, the certified mail, the green card endorsement over here in this country for the endorsement, and proving the delivery there, then you're going to do the, after that, that's when the trust really formed, when you sent it to them. But let's say you waited a whole week, and you waited until you did, say, the record creation, the UCC 1s and the 3s, and then the recording into the county, to create your two records for the claiming of the titles and the actual moving of the titles, which would be the trust res. And that could be, say, a couple of days afterwards, or maybe a week, say. But the two records that you're creating, that's the actual public notification of existence of a trust that was formed, say, 2 or 3 days prior or a week prior as the present transfer.
Okay.
So are you following me so far?
Yeah, I'm with you so far, yeah.
Okay, so now you've got two records on the claiming of the title, which is making it mine, and you're putting it on the collateral block 4, you're claiming that as the title. So now it's yours, you can do something with it. So that's the UCC 1, creating one public notice, and then I'm going to record it in the county, a notice again, pull that out certified. Now I got my claiming two titles, or my two records for the claiming of the title. And then I'm going to do the UCC 3, indicating that it was a transfer 3 days or a week prior to that. And then I'm going to do another county. So there's my second two witnesses proving that I transferred the property. So now I've got the records that I can use to prove the trust.
The public records you're talking about a UCC 1, as in a non-UCC 1 would do, wouldn't it, as one of the public records?
A non-UCC 1, right? That's the claiming of the title. Then the UCC is the 3, the UCC 3. That's the transfer of the title.
Yeah. Okay. No, I'm just trying to figure out. I need two public notifications before I do the UCC 3 transfer. A non-UCC could be one of them. We don't have county recorders here, so what would constitute a second public notification? Would it be like a public notice in a paper or something?
Yeah, if you have that ability for doing that as evidence, yeah. In this country, we can do a publication in the newspaper, and that's just as good as county recording them.
Okay, very good. Now, when you're doing a public notice, sorry, can you hear me?
Yes, go ahead.
When you're doing a public notice in a newspaper, do you have to disclose the entire content of what you're doing, or can you just make a reference to it?
No, like, you don't want to disclose it all. You just want to give notification of an existence of a private document, say, that has been claimed, and I'm the holder and the owner, and it's my right, title, and interest to, say, a specific number of a res property, which would be, in the case that we use, is the RA number, registered mail number, RA, and then the 9 digits and -US. That's the number on a registered mail number. So we're uniquely identifying a specific number, but there's no reference given to any kind of details of the document other than it's just that specific number referencing to the actual documents with all the details on that, not the notice itself. You know, the details are not noticed on the notice, but the details are held privately. So I'm just trying to give it enough to. I'm like reflecting it into the public, but yet they can see that something exists, but they don't know what the details are.
Okay, perfect. And you're saying then once you have your 2 public notices that you can then proceed on to UC3 to indicate a transfer that happened probably 3-4 days prior to this.
Right. Now, I'm assuming that your country is the same as ours, but before I did that, I would want to make sure and check that, public notification is, that you could do that in your country.
Yeah, I mean, we can do public notices
in our evidence rules.
Oh, right, okay, I can check that under evidence rules, no problem at all. Okay, so basically, once I have that done, once I have my transfer, once I have my UCC3 done, and assuming everything is okay with the public notices, that's basically my proof of trust, isn't it?
Yeah, with those 2 documents, you should be able to prove that somewhere in the past there was a present transfer of trust property. And it's going from the grantor to the trustee.
Okay. On the actual res itself,
and he's got trust res property, and there's a trust been formed.
Fantastic. Now, once the trust has been formed, the trustee obviously has a duty to fulfill this particular obligation or whatever. Yeah.
Right.
Okay. On the actual res itself, I would be placing this certificate of dishonor and non-response as the res itself. Do you think I should put an actual value on this particular document before I issue it to him?
Yes, I think you should put an affidavit of obligation on there with a true bill. Yeah.
Affidavit of obligation. Just write down this here, Christian. Okay.
The true bill would contain the specific value that you're going to state on the dishonor.
Okay, that's
that would add law, and the equitable part of that, which is where the trust side is. We're not really concerned so much about value, but you can dual it. It's because it's like the same door having a front side and a back side. Well, the front side could be, say, the public side, which is the known value that you're going to express this dishonor to be worth, and the back side is the trust or the equitable side, which is not really concerned about a value at all because it's a thing, or it's the res. Does not have to have a value.
Christian, merging the titles then. Merging the titles is basically, this occurs where you've been made a trustee by their trust, and you've established yourself as grantor or beneficiary of this particular new trust. That's merging the titles, isn't it? Because the one person becomes the both roles, if you want to put it like that.
Yeah, anytime that you got the beneficial title and the equitable title merged in any one entity in the trust terminates.
And once the trust terminates, the resulting activity that results, I suppose the best way to put it, would be the disbursement of the funds. How does that happen, Christian?
Well, the trustee has a duty to wind up the trust and disperse the funds, and if he doesn't do that, then he's in breach of trust and possibly done a conversion, and could be under breach of trust, conversion liability for that, and other causes of action against him for whatever.
And disbursement of funds is basically would be disbursement of whatever the value set out on the res.
Yes, we're at the analog side, yeah. Mm-hmm.
Would that mean the offset of the actual obligation on their end, and then the balance dispersed to the grantor, or how would that work? I'm just trying to get my head around it.
Let me see. Trust deposit under Black's Law, Fourth Revised, says that where money or property is deposited to be kept intact and not commingled with other funds or property of the bank, say, and it is to be returned in kind to depositor or devoted to a particular purpose, or requirement of depositor, or payment of particular debts or obligations of the depositor. And it's also called special deposit. So there's your payment of a particular debt or an obligation of the depositor, since you're the depositor, the grantor, so you just did a trust deposit.
So we'd say if your trust deposit or res in this case would be 100K, and the actual obligation itself on the public side, or we'll say their trust terminology side, would be 20K. That would leave obviously a differential of 80K. What happens to that? Does that just stay, or
probably ask disbursement back? Yeah, the overage.
All right. Okay. Fantastic.
Then in order which the person the section on that. I have to look at one up. I believe it's in the restatements, second. Yeah, I was right. I didn't want to flip it up. But anyways, section 342 under the restatement of the law and trust, it's direction to convert. Okay. So although by the terms of the trust, the trustee is authorized or directed to convert trust property on the termination of the trust, the beneficiary, not under any incapacity, can require the trustee to transfer the trust property to him without converting it. So under this case, if you got an obligation, you probably want to give an order to, or direction to convert it.
Okay. Sounds good. Sounds good to me, Christian. My second question is shorter. Why would, in what situations would somebody create a discretionary trust?
Well, the purpose that they've done one over here for the protection of the rights and the assets of the beneficiary from anybody getting at their assets, because under the modern view, they're saying that in order for a trust to be a trust, it has to be transferable or alienable.
Yeah.
But the reason why they've done that in violation to, say, our Declaration of Independence, which plainly states in that the beneficiary has unalienable rights, non-transferable rights. So they've done that for the purpose of taxation, so they can get at the assets.
All right. Okay.
So if you have a situation where the beneficiary is insolvent and you wanted to protect the beneficiary from anybody getting at his assets until he became solvent again, that would be an ideal thing what you would do. Form a protective trust and then put it under discretionary trust.
Okay. Yeah, I've just been looking through the tax. Sorry, go ahead.
Yeah, the Gilbert's book was that rationale was, they were saying that it was actually the better way to go.
Yeah, because I was going
protective trust, right? Was an intended result somewhat comparable to and in fact more than the result of the Spendthrift Trust. But it says that it is logically less objectionable, in that the beneficiary can't be sure of receiving substantial trust benefits only as long as he keeps his debts paid. So in other words, he has to be a good debtor under debtor-creditor, and then he'll get his trust assets. So the trick is to reverse that.
Would somebody
Go ahead, what?
Just thinking, would somebody, would you use a discretionary trust? Because I've just been thinking, like, in relation to special deposits, would somebody use a discretionary trust to, we'll say, probably derive an income for a certain beneficiary? Would somebody use a discretionary trust to do that? Would be,
yeah, it could be for the maintenance and benefit, for the beneficiary, yeah.
Okay. I've just been going through some of the tax information here in Ireland, and I just came across a discretionary trust tax return form, and I was just wondering about it. Could we come in from a position of special deposits in this sort of a form, and lodge a particular trust res into this particular trust for the benefit, obviously, of a named beneficiary. Yeah, that's cool. Christian, thank you so much for your help. You've been fantastic, and I really appreciate all the work you're doing here. This is awesome, even though I'm a baby yet. But I appreciate your help. Thank you very much.
Okay, thanks, Dominic. Okay, another question. Anybody? Press star 6. State your name, where you are. Where are you from?
Yes, Bill from New Jersey.
Hi, Bill.
Hi. Christian, your treatises on trust by Llewellyn, you talk about putting the statute of uses of 1536. Does that make it possible for the beneficiary's rights to be alienable or safeguarded?
Under the statutes of uses, they were trying to make it so that they could transfer the property back then. Yeah, so
now, was that common law, or how does that? I get confused.
Oh no, trust is not common law. Trust is solely equity.
So in common law, they couldn't transfer the rights. So
let me see. Yeah, that would be the at-law side, the common law. So that answer the question.
Right. So that's
common law is the at-law side. For trust is on the equity side. So there's your private side under equity and your public side under common law.
Okay, on the public side.
Now remember this. before 1933. So we still had the ability to form contracts because we had real lawful money.
Right. Well, this is like in 1536 even.
Right.
So I get confused. I'm thinking that things evolved since between 1776 and 1536. Things evolved.
Yeah, because they went from the statute of uses to the statute, or for the use changed to a trust.
Yes.
Trust. That was the new device that they created.
So the use is different from a trust.
Well, it was the forerunner of it, let's put it that way. They were calling it a use, but it was really functioning as a trust. But then they formally changed it and made it official. This is the new device we're going to use, and we're going to call it a trust.
So again, when they made the statute, the beneficiary's rights could not be assigned away. Is that what happened?
Well, it's dependent upon the indenture or the will of the grantor, because he is the one that is the law of the case or the law of the trust.
Mm-hmm. So then, why did they make the statute of use?
His will or his. Yeah, it's whatever the grantor.
So what was the purpose of the statute of use?
Courts are reluctant to go against what is written in the indenture if it was in writing or whatever the grantor's will and intent was.
Oh, I got you. Okay, I got it. Okay. So, and what way does that impact how we are today? Just because I'm thinking everything before.
Well, they caused us to do a divergence in a parallel path then, and they continued on in the feudal law and just took the definitions of the old terms and took the words of the old terms, and still operated under the feudal system.
Until when?
Until now. We are still under feudal system.
So then what difference does it make between before 1933 and after?
Well, they're confusing us to be under the parallel path, being debtor creditor, an expression of operating under a statutory trust, say, when all along it's really operating under a feudal trust law.
Wasn't a statutory law?
Say that again. Statute of uses what?
Wasn't the statute of uses of 1536 a statutory law?
Yes, but that was the statutory law. I say those are common law. But now, what is statutory today? Statutory.
I don't know.
It's totally different.
Okay, so even though it's statutory,
we flip-flop from having lawful money to now we have everything as legal money, which is not lawful money.
Mm-hmm.
And then we also had a parallel path change also. So we had like a double flip-flopping away in our minds.
Oh, I see. I got you. Okay. So when we look at this, we have to look at it from a two-tier system, at least two, maybe three.
Yes. Yeah, because anything that you read, you got to ask yourself, is it pre-UC or pre-1933 or is it after 1933? Because now, excuse me, if it's pre-33 or post-33, you're going to have to just first, look at that, because that's going to keep it in context. Then also, is it on the parallel path, or is it on the same path that was continuing on?
So now, when we read these treatises by Austin Wake, most of these are pre-1933. Now, how do we? Excuse me.
Yeah, most of his stuff was pre-33.
Right. So when we read these cases, how do we take these cases in context of our particular approach, especially the trust and the private side?
Well, anything that's pre-1933 is really how they're really operating.
So, in other words,
on that path straight through 33, and kept on using that same path, except it caused us to do the divergence and form this parallel debtor-creditor path and get us to perform under the debtor-creditor and a statutory trust also.
So the step and wait, also the wait is that's the body of trust what we want to use. Is that what you're saying?
Yes, anything before 1933.
Mm-hmm. Okay.
And that treatise that we're using by Lumen, that one is the first American version.
Right.
That's the first American edition.
Now,
so we want to take that old there because that's the first one to give us how it's progressed and how it's been transformed or whatever they're using, and then just before the 33.
Right. This is more modern.
Like that older stuff.
Yes, a little complicated.
Yeah, it is. It's what they've done is they've really confused things by what they've done, and it's really kind of hard to understand sometimes because we think everything is the same. We think the law form is the same, and we think, but it's not. All this stuff is not the same. Equity is not the same today as it was back then. Statutes and codes are not the same.
Exactly. That's my question. There seems to be a difference, and that's what I'm not getting. If you say equity, without saying, I'm not hearing in my mind equity before 1933 or equity after 1933. What is the real difference? That's what I don't get.
Okay, equity in before 1933 was whatever was fair and just. And equity was used to compel you to not breach a trust, say, or to compel you, if you did breach a trust, to do the duty. Now today, after 1933, equity means nothing more than the statute and code obligation, because equity has been combined into one form, and we call it summary judgment. Now, that's on the public side of the court. Today, after 1933, the true equity cannot be gotten on the public side of the court. You have to go into chambers to get your pre-1933 equity remedy.
Okay, I got it. I got you. So that's why
they've done a through on what equity means and common law means, and they've said they've combined it and made it into one form, which they didn't. They really did away with it. They locked up common law and held it in trust with the republic and with the lawful money. It's being held in trust, and that's where America is today, in trust.
Right.
But it's in equity in chambers. It's locked up in chambers.
So we can only get equity in chambers.
Only get equity today of the pre-1933 version equity, only in chambers today. Because equity on the public side of the court is totally different. It's nothing more than statutes and codes.
When we say express to trust, that's implying pre-1933. Is that right, for our purposes?
Well, you can play with statutory trust and go into court on the lawful side, and you could do it that way.
But we want to eventually have to go into chambers, right? In camera, right?
Well, yeah. I could probably win just by statutory trust law on a black statutory trust, rather than I could probably go in and enforce it under a white trust. And a white trust would be the, say, pre-33 trust, whereas the statute and code trust today, post-33, which is likened to Gilbert's book on Gilbert's, that's the black trust.
Right.
So I liken it to say it's black.
So there is enough in the Gilbert summary, under trust law today, there's enough, as you say, for us to go in on the statutory side and still seek a remedy.
Because you're going in under debtor-creditor trick and under disguise to be debtor-creditor. It's the camouflage that's really holding the key, keeping you from the realization that it's really a trust that they're coming at you with, whether it might be just you come in as claiming a statutory trust. You could do it that way.
It's the same thing that Bill from Michigan said, that when he and his associates expressed the trust, the cases of trust, he said that things changed.
Yeah. Once we get a handle on what's going on and we try a few different things and get this actually laid out how they're doing this, and then we'll have a key.
And then our backup is the private side.
Yes, because that's the superior trust, that's the master trust.
Right. Okay. Thanks a lot. Appreciate it.
Okay. Anyone else? Let's start. State your name, where you're from.
This is Isaac from North Carolina.
Hi, Isaac.
Christian, I've been studying what you've been talking about recently. I actually came to the same realization. In some ways, it didn't follow through about a year ago. But I've also been studying the implications of Reconstruction in America, specifically with the state of North Carolina. And I was kind of curious as to how the trust aspect of things that we primarily discuss on here falls into relation to the overthrow of lawful government and the subterfuge of, the common law, basically. I just wanted to kind of hear what you had to say about that and try and gain some perspective.
Well, I don't think it. It's really we dropped the ball as Americans, we the people, because we had the first duty to express the trust. We never expressed the trust. We dropped that ball, and they're sitting there looking, for the instructions, and they're not getting any instructions. We're not giving them the instructions.
Well, I understand that aspect of it, but the kind of the question I have is, a lot of these things were done at the point of a gun, and
yeah, I understand that. I'm not saying that what they've done is totally, wrong.
Mm-hmm.
But what I'm saying is that, we fell down first. We have the kind of government that we've created, and because we didn't know or understand what we were doing, we were the first ones. Now, here's what I don't like, is because you guys are blocking our remedies when we are finding this out, and you're not really disclosing to us what you guys really did.
Mm-hmm.
Yeah. I don't agree with that.
Yeah, the big propaganda that's pretty evident.
I can't help the way things are from what I did in the past, but today and tomorrow I sure can change things, and that's what I'm looking to do.
Yeah.
I'm not crying about what, let's clean the milk up and get on with life, and, I'm not going to point any fingers at anybody and say, hey, let's just forgive everybody and let's go on and make government the way we really want it to be, as according to the Declaration of Independence. If we're sick and tired of the way government is being handled right now, then I think we need to get into the knowledge and the understanding on how to do government first, and then get in there and change it.
Yeah.
Enough of this stuff about finger at somebody else. Let's get in there and say, what can I do to change things?
Okay.
That's the only reason.
I agree with that.
That's what.
Now, I've been reading some of Maitland's stuff as well, and I had a question in that regard because, according to Maitland, the common law and equity have to kind of coexist, and equity can't really exist without common law. So, ultimately, aren't we trying to get back to actually being able to execute common law contracts at some point in time as well, you think?
Yeah, you get the money back out of and get the republic back. Yeah, you'll have the ability to execute contracts.
Okay.
And what the contract can do, enforcement, then equity was designed to enforce that. Because equity, that's where equity's purpose is for. It's for the enforcement of compelling somebody to do something after they've breached, or compelling somebody not to breach the contract or the trust.
Have you ever read Pasco Gord's The Common Law and the Law of the Lord? Have you ever read that before? I'm just curious.
No,
okay.
I have.
I would take the time to read it. It goes back to King Alfred, supposedly the first king of Britain, and he states the origin of, I guess, the common law, so to speak. It's pretty interesting reading in regard to common law as well, because I know it's morphed over the last 1,000 years from probably more than that, 1,500, maybe even further back than that. Anyway, I'll leave you with this, and I appreciate your time. Thank you.
Okay, thank you. Anybody else have a question? State your name, where you're from. Press star 6.
This is Kevin from Maryland.
Hi, Kevin.
Hey, what's up, Christian? I had some questions. First of all, just going back to the signature, can you put grantor / beneficiary when you sign your name? Or just have to be
yeah, you probably could.
Okay.
Yeah, if you're a grantor or beneficiary, well, you could put it on there, yeah. But then again, you're nailing it down, more specifically.
Because I was thinking if you did that, couldn't you possibly say if I lost my Social Security number, right, or card, couldn't I go back and fill out that SS5 again and send that in? And once I'm delivering it to them with that signature, and I'm expressing it on that, and that's a way to say I've expressed trust.
Yeah, that does have some records that you can express it that way, yeah. But I don't really have to do it that way, though.
Okay, I was just curious. I was just thinking maybe you could do it like on the SS5 form, maybe SS4, or also, even if we're going through problems, I'm thinking you can always go back and just say, and just revoke the trust. Now, can we actually revoke the trust and restate it and make a new trust? If it's not being carried out according to our intent?
As grantor, yes. Mm-hmm.
Now, okay.
Beneficiary make that.
Okay, so that's one thing we can.
Christian, this is Bill in Michigan. A couple comments, because I have some direct experience with exactly what he's talking about. There is a form for revoking that trust, and I don't remember what the number is, but the IRS or Treasury has a form that you can do to basically wipe out your Social Security number. They try to. The form is structured to discourage people from doing that for obvious reasons. But with respect to the first comment that you had, in how you sign the SS5, I actually went in and did that last year and signed it as by, and then my name, and then authorized representative. And the reaction I got was quite violent from the agent that was there. They told me that I could not do that, blah, 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 blah. I pulled out my driver's license and my passport, of which was signed in that fashion. So well, you can't do that on the SS5. So I said,
I was just thinking that if you send it in, and once, certified mail, registered mail, and
you can't send those. I don't think you can send those things in. You got to do those in person, because they want to see you signing those things.
Oh, okay. I was thinking that.
I don't think you could send those in. Somebody you can you can do that for newborns, but I don't think you can do it if you're getting a new card. I think you've got to go in there. But here's the workaround on it, if you want to know what the workaround is. What they do is they take that SS5 and they shove that thing into a drawer. So the next day I went in and I went up to the counter. I got a different agent. I said, I was here yesterday. I filled out the SS5 and I think I made a mistake on my signature. And she pulls it out and she looks at it and says, it looks okay to me. And I says, may I please look at it? And sure enough, there was a mistake on there, and I corrected it, and I gave it back to her and walked out. And that was the end of that.
Okay, now, I guess my next question is, I think...
What did they do? Did they change the package?
No, they can't. It's my signature. I put the word by in front of it and put the authorized representative and gave it back to her. Half these people don't understand it. It was a supervisor. I was asking a bunch of questions, okay, and the agent that was helping me brought the supervisor over, and she was a 300-pound female, and, you know, she was asserting her territory. So I wasn't going to argue with her because there was no point in it. I knew if I could come back the next day, which is what I did, I got a different person. I mean, these people out in the Matrix, if you start to assert your rights, they start to get a little bit defensive because you're crossing the line of what they believe is their control center. So, you know, we have to be respectful, but still assert our rights politely, and don't say no. You know, don't give up until, you know, you've tried another person. We've had this many times. Go to the next window.
Okay. Also, I have a certificate of non-response that I've already sent in to the IRS, and so I guess my thing would be I've already I can now go file a UCC 1 on that, and then from there file at the county recorder, and then come back and do a UCC 3, and then also file those, and those would be my records. Because I sent it to the IRS manager and the operations collection manager who did the notice of levy for me. So
did you have a green card?
Yes.
Did you have a green card?
I had presentment done by a notary, and they had the green cards that were done and sent from the notary, and they had to return to the notary. And I had the green cards, but they acquiesced. They never get a response. And on my affidavit, because that's a certificate of non-response, I told them that there is no more debt and that I have been injured. So, I mean, and they never answered it. So I just need to file that
now? That represents the transfer. Yeah,
okay.
That represents the endorsement on the green card. That's your endorsement, your delivery, that's your transfer.
Okay, so I'm assuming that it's on the UCC 1 that I go ahead and express the trust, I'm assuming.
No, that's just you're claiming that title as yours to be able to transfer it on a 3.
Okay. So just by doing, so where am I actually expressing? Since I've already done my certificate of non-response before I learned the trust about trust.
Well, actually, it's the green card. That's the proof that you delivered something to it. That's the present transfer right there. But now you're just creating another record of that fact, and that other record would be the UCC 3.
So I have UCC 1,
and then the county recorded it back then. But yeah, well, the 1 is just I've assumed that you claim it. You got to claim it.
Okay, so I
can't transfer it if I don't have it. If I didn't claim it first, I can't transfer it because it's not mine.
Okay, so I have to do the 1.
So I'm creating a record that I've claimed that it is mine, and now I've got the right to transfer it.
And then I do a filing at the recorder after I do those. Now, I guess my next question is, where do I want to make sure I understand, where have I expressed the trust at this point, since I'm just learning about the trust, because I've already done the certificate of non-response.
Well, you expressed when you sent the trust res to the trustee. That's when the present transfer occurred. That could have been in the past. But there has to be a present transfer of trust property. Whenever you send it to the trustee, that's when the trust was formed.
I guess I'm not quite comprehending it. I thought there had to be some point where I understand the recording that I'm doing, but I guess at this point I'm trying to get the actual expression of the trust. And since I haven't done the 1 and the 3 yet, I haven't actually claimed and transferred it to the trustee yet. So I guess what I'm trying to say is,
it's your intent and purpose to create a trust and do whatever your purpose was for the special deposit, say. But the trust forms when the trust res property transfers to the trustee. Okay. That is your expression of the trust. That's a manifest intention of the will of the grantor, which is his intent and purpose.
I do the special deposit. Okay. And then when I do these other UCC ones and the UCC 3 and special deposit, I can sign as the grantor and the beneficiary, or just leave it as grantor.
Say that again. What kind of deposit? The special deposit you said?
Yes. I do special deposit after I've done the
deposit. I would really, it's kind of not necessary to put the beneficiary, if I'm the beneficiary. I'm just going to make the deposit as grantor.
Okay. Okay. All right.
What hat am I wearing for act that I'm doing? Is it a grantor act, or is it a trustee act, or is it a beneficiary act? That's how I'd want to be signing. Whatever act comports to whatever position I'm doing by what I'm supposed to be doing for that party. If I'm doing the special deposit while I'm acting as grantor on this, then I would sign by grantor.
Gotcha. Okay. So keep in mind what I'm doing, what I'm actually doing at that time.
Yeah, that's how you're going to sign. That's the restrictor you're going to sign by, whatever hat you're wearing in the trust.
Okay. Now I heard of Form 56. I've seen that form before. Is that form only used if you have a court case?
Well, you could do that form. It's for the IRS for appointment of a trustee.
Oh, I could do that in my case then.
Yeah, you could use that form.
Because when I saw that form originally, down at the bottom or the next page, however it goes into the next page, it said put down your court case number. I said, I've never had a court case number. I've never been to court with them. They just went ahead and there was no due process. So I was just curious. I've seen
that being the dip, whatever the dip hearing is, that's where you put in there.
Okay, yes, I haven't had a dip hearing because I'm waiting on my Freedom of Information Act. So I was just looking at other things I could do till then. Okay. Thank you.
All right. Another question, press star 6. State your name, where you're from.
Hello, Christian.
Think about you, Dave.
Hey, I heard your program last night. I just don't say anything. A lot of times I listen. I'm really dull. I might jump in.
You gotten bashful or what?
No,
got bashful or what?
I got bashful. No, it's just some people, they may have issues that they need to address right away. Like our friend overseas, he's got something coming up in a couple of days. Right. I know how that can be. But you mentioned the registered mail number. That's not a number that you have to send through the mail to validate it. It's just any number that you get down at the post office. Is that right?
Yeah, I just go there and ask for a registered mail sticker and then send that to myself and get it canceled, pay the fee. And now I've got that number to use for any particular thing I'm going to use it for. As
so it does.
Specific identifier on.
So it does have to go through the mail system then.
Yeah, cancel that sucker. Yep. Pay for it and cancel it.
Well, great. I'm having to do that with IRS envelopes too. When you get one from them, it's not canceled. And so I put some stamps on it yesterday, put it back in the mail. They came back to me, still not canceled. So I took it down there to the postmaster and I said, aren't you supposed to be in compliance with U.S. Postal Code Manual 3.4.8? And she looked at me like a calf at a meat gate. I said, well, that means everything has to be canceled. And you didn't cancel this. And she said, well, that's got their little stamp on there, and we don't, that's pre-canceled. I said, it's not canceled at all. There's no postmark. Anyway, to make a long story short, I just bought another 42 cents worth of postage, covered up their little stamp, and put it back in the mail. So I bet I get a canceled thing now. But the reason I'm doing that is to prove that what they sent me is what I said they sent me. And so I'll have a notary open that, and he'll make a copy, and he'll testify that, the little bag of tricks that they do you. Anyway, the point, other dot I'm trying to connect was when the husband and wife are both, joint buyers, or they can mix and match. They're both grantors, they both stated they're grantors when they were at the closing table. But in the court case, the guy can say, hey, I'm the grantor, and the law of the Bible, and my law says let every word be established by 2 or more witnesses. And right now, we're the only witnesses. And those other guys, they don't have nothing. So you need to tell them to take a hike.
And remember, that's only available to you in equity in chambers.
Right. You have to go, and that's where we're headed. But I wanted to ask you, you had quoted many times, and especially in the early days, a certain statute that if you come in the front door in the public, you waive all your rights to whatever you bring with you in that front door. Would you have that on the tip of your tongue so I won't have to go look at that and all those other things?
That's 90.506 and 507.
You're awesome.
Florida statutes.
Yeah. That's Florida, though. So it's in Texas. I got to find the Texas equivalent. All right, that's awesome. Thank you so much.
A waiver of the privilege by voluntary disclosure.
Mm-hmm. Now, your next program is going to be, is it tomorrow night?
Tomorrow night at 8 o'clock on Talk Show.
Yeah, and this one tonight, the recording for it is accessible when?
It'll be up on the website, movingtitles.com.
Okay, how long does it take for that to show up?
It could be like one night, or it could be 1 week. No, depends how busy I get. I got last Saturday's put up there. I got one done. I just hadn't had a chance to put it up there.
Well, you're doing a great job.
Yeah.
Now, in regards to the workshop, is that going to be a real basic beginner type workshop, or are you going to predicate it on the level of the students?
Well, yeah, kind of on the level of the students. I don't know how far back we have to go, but if we have to teach, how to move titles first, about the moving title, that's what we'll have to do.
Do we have to take a IQ test?
I've been spending so much time really with the workshops, just so that we can get this explained and kind of build up a momentum and get a foundational knowledge set down first before we get into the more practical stuff and doing the paperwork.
Right.
Because if you don't understand moving titles, that seems to be a big stumbling block. Everybody's confused about these UCCs, how we're using that. We're not using UCC like UCC was in debtor creditor.
Right, it's unnoticed. Totally public notice. Is that right?
Yeah. And then a lot of confusion about when does the trust form and, where does it form? People are not thinking, go back to where the first signing was, because how did you sign? Or where did you sign, really? Because, you might not have signed by grantor, but yet a trust was still being formed there. Because back to the big picture.
Is there any other evidence of proof of the trust that we have to show besides the SS5 and just verbally describing I signed a note, and the trust relationship back then was that I would get the note back. Well, I asked for it back, and they don't have it. So they're in breach of the trust.
Oh. Breach of trust, yeah. Conversion. They commingle the funds.
So, Mr. Judge, I want you to take care of this. He's going to shrug his shoulders now. How do you want me to do that? What? You're the trustee. I got to pay you everything?
Pretty much so, because, it's up to you to prove what you claim. And then once you prove what you claim, then the judge is obligated in a box. He's got to enforce, what you proved.
So you're basically going in the chambers. Your claim is there's a trust relationship here. It's not an agency relationship. And then as I'm the grantor, and you've got the assignment to take care of this, which is right. How do you bring up the subject of merging the two titles? Because you think he's really going to understand that? He doesn't know what two titles. What are you talking about?
Yeah, you're probably surprised how much the courts really do know, especially the higher up judges.
Well, what makes you think you're going to get a higher up judge? It's usually a low level. You know, the first time you're in the court is one of the lower courts. Now, I had this attorney with me. I got to tell you this real quick. He said, "Well, what do you call an attorney with an IQ of 80?"
Yeah,
Your Honor. Sorry for you attorney friends out there. Look at the judge. But let's presume that they act dumb and they want you to explain it to them. So say I'm a dumb judge, and I said, well, why don't you explain that to me? Just to know it all.
Well, you know, I can't in open court because if I talk about my CCI, my trade secret information, you know, that's all privileged stuff, and I object to even discussing it here in open court.
Well, I agree.
We're in chambers and talk.
Yeah, let's say we are in chambers. You tell him to take his robe off?
Yeah, he's going to take his robe off, yeah, if he's in chambers.
He's cross-dresser, you. Now in chambers, he's going to say, explain to me what you want to do now? Want me to be the trustee? Sonny? Sonny boy?
Yeah, well,
Well, I don't think any trust here.
The title is first, so you're the trustee, and you got to wind this trust up and disperse the funds.
Well, what funds are you talking about?
Well, that's the special deposit now. Would you like to take a recess and you go stay up on this and come back?
Well, no, I want you to tell me all about it.
Christian? It's not I'm not practicing law. You're the judge. You're supposed to know. If you don't know, then I suggest you go find out.
Okay.
Yeah.
It's Chris in Florida.
Hey,
guy. Would the disbursement of the funds be the bid bond, performance bond, and payment bond? That they're trading in the first one?
Would the disbursement be what again, though?
The bid bond, performance bond, and payment bond that they're already trading with your TUSIS number on the exchange.
Well, I would incorporate those as being proceeds of the, say, special deposit, yeah. So it incorporates all those. Actually, it's like whatever the value or the title to the debt is going to be an equal amount title to the asset. And I'm going to take those two titles and move them or merge them into one entity, and then that trust is going to terminate. So I really don't know if I'm going to get any funds back.
Now, if you were to get a chance to read the Alfred thing that I sent you,
I've read that in the past.
Now, in it, he says the beneficiaries are always at the mercy of the court. So, when we make him the judge trustee, are we the beneficiary, or are we because he says the beneficiaries have no rights. So he says trustee means you can have full rights.
Right. At law, they don't have any rights. In equity, they do. They've got all the rights. Under this treatise that we were reading, you look at it as being the trustee, they're really looking at it as the beneficiary and has all the rights.
All right, but if we're the defendant, are we the grantor settler, and then the judge is the trustee, and then the plaintiff is the beneficiary, or are we the beneficiary, and who's the grantor settler?
Well, you can play this in a court setting, just like we talked earlier today. Earlier, we talked about you can play the beneficiary role, or you can play the trustee role. It just depends which way you understand how you want to play it. You can be grantor, trustee, or you can be grantor and beneficiary. I see a win-win situation either way. It just depends on whichever way you feel more comfortable coming in. Grantor, beneficiary, I'm going to make the claim, have the titles merged, and I'm going to get the disbursement, or the purpose of what the grantor was, which is myself anyway, which would be the obligation to pay the debt. Now, if I'm grantor and trustee, I'm going to say, okay, I am the trustee. I have not made a payment, so now there's no controversy in this case. But now let me tell you the reason why in chambers, why I have the legal duty not to make a payment. Why within my rights as trustee. And that would be because of a discretionary trust. The discretionary trust is in place, and I can't give the beneficiary the assets, because if I did, the creditors would jump all over it, and I would be in violation of the trust purpose. I can't do that. Legally, I can't do that. And that is the reason why I legally withheld payment. So either way you want to play it, you got a win-win situation. So in that scenario with the trustee, and if I'm that, and oh, by the way, here is an instrument to pay to the beneficiary to make him solve it again, so that the trust can now terminate the discretionary portion of it. So you see how that works? Either way.
Interesting. One of the things he does say is that over your signature, you should put it arm's length. Have you heard that term before?
Yeah, I kind of remember that when he said that, but some of the stuff he wrote there, he kind of wrote it in a duality so that he took the middle road. Because I think he was trying not to ruffle any feathers of any kind of thinking for maintaining publication, readership.
Right.
Because he kind of took, he went back and forth, vacillating back and forth, the way he wrote those articles.
Well, this is what he said. He says, perhaps we could post public notice in a newspaper declaring that unless we expressly declare otherwise, in order to preserve all of our unalienable rights, all of our transactions will be conducted strictly at arm's length, in quotations. Ultimately, we might add an arm's length disclaimer over each of our signatures, or as a codicil to all of our contracts, to notify all others that we won't enter into an implied or presumed trust relationships.
Yeah, that's exactly what the arm's length was.
He says, even so there is a term defined in, to give you a definition, he says in several editions of the Black Law Dictionary, which seems to ward off constructive trust, much like garlic wards off vampires. He said at arm's length, the term is defined in Black's first edition, 1891, and fourth edition, 1968, as follows. Beyond the reach of personal influence or control, parties are said to deal at arm's length when each stands upon the strict letter of his rights and conduct the business in a formal manner without trusting to the other's fairness or integrity and without being subject to the other's control or overmastering influence. And then he goes on, the classic definition of beneficiary is one who trusts. Therefore, one acts only at arm's length. he would seem to do so without trusting, and thus couldn't be a beneficiary. So he's saying that you really should put at arm's length over your signature.
Yeah, that was one of his disclaimers. Yeah, I remember that.
And one of the things
I don't know how well that
was that beneficiaries have no rights. It's basically the trustee that controls. The trustee directs.
I'm not disagreeing with that. I think beneficiaries are the ones who have all the rights. Trustee has legal title and possession.
Well, what he's
trustee can do whatever he wants with the property.
Well, this is what he said. He says, by definition,
beneficiary.
By definition,
the trustee has full possession and legal to the property trust rests, and he can do whatever he wants with that trust rest. But he still has a duty and an obligation to the beneficiary, and the beneficiary has a right against the trustee. It's like out of Black's Law, when it talks about the under the trust definition of Black's AIDS.
Well, this is what he says.
That's one thing about the last article there. He kind of takes and he plays both sides against the middle. And I don't think he sticks with one particular thing. He vacillates back and forth. Because under the definition of Black's Law under trust, it says that some courts and the legal writers have defined a trust as a certain kind of right that the beneficiary has against the trustee, or a certain kind of interest that the beneficiary has against the trustee, and a certain kind of interest that the beneficiary has in the trust property, thus looking at it from a point of view of the beneficiary. So it's a certain kind of right, a certain kind of interest, a certain kind of title, really, right, title, and interest that the beneficiary has in the trustee and the trust property. So I would disagree with what he says there, based on Black's Law definition. Beneficiary has all the rights.
Well, this is what he says. He says the problem with beneficiaries is that they have no legal rights within the context of the trust.
Legal rights. Legal rights.
Hold on.
Beneficiary has legal rights, yeah.
Hold on. The problem with the beneficiaries is that they have no legal rights within the context of the trust. The reason for this disability is that according to Bouvier's Law Dictionary, 1856, all rights flow from title.
Yeah, title.
For example, the reason you can drive your car but you can't drive mine is that you have a title to your car, but you have no title to mine. Your right to live in your home or apartment.
Hold on just a minute. It depends on whether you're looking at the present tense, who is holding the title. But who ends up with the title in the end? The beneficiary. Because he's supposed to, the trustee is supposed to terminate trust at some point and pass title to the beneficiary. So in the end, the beneficiary has all the rights. Has all the rights, the title, and interest.
Well, let me ask you this.
If you're looking at it, the trust in its infancy or it's being in its administration, then yeah, the trustee has all the rights temporarily. But he has to do what he has to do according to the indenture and then give everything to the beneficiary.
He says trustees have no...
Say again?
He says trustee means you have no equitable rights in trust property, but beneficiaries, by definition, have no legal rights to trust property.
True, right. Legal title is in the trustee, and beneficial title is in the beneficiary until the trust is terminated, and then the beneficiary winds up with them all as a merged title.
But he says beneficiaries are always at the mercy of the court, which kind of, scares you if you go into the court and you're going to make him trustee and now you're the beneficiary. Because now he can direct to what's going on. For example, if you got a rich Uncle Charlie and he's the grantor settler of this, multi-million-dollar estate, he hires a trustee to direct the trust after he's gone, correct? And if you're the beneficiary of it, you have no say-so. Let's say you're 18, the trustee has been dictated by the grantor settler.
I have no say-so on how the trust is managed, but I have a say-so because I didn't get the titles, because I'm the one that's supposed to wind up with them.
What titles?
So I can make a claim against them.
Well, let's say, for example, it's just money. You're 18, you get $1 million when you're 18. And the trustee says that according to the grantor settler, he says that, you're supposed to get another $5 million when you're 21, and another $5 million when you're 25. So you have no say-so. You're benefiting from it, but you don't have a say-so like the trustee has the say-so. Of course, you don't have a...
But it's all against the indenture, whatever the indenture.
So isn't it true that in a court system, if you're going to be the beneficiary, you might be in trouble where if you're now the grantor settler trustee, you're directing what's going on, directing to the judge what's going on, making him the beneficiary where he has no right in that situation.
Oh, no, wait a minute. No, I'll back up. If the trust has been breached due to a wrongdoing of the trustee, now I got a claim. It all depends on the indenture. What was the grantor's will and his purpose? Because if there was a breach done by the trustee, now I got a claim as beneficiary.
Okay.
Create a hypothetical, Chris, with the mortgage application, where the fraud is all on the other side, and you claim the position. You claim the position as trustee in the matter, and reappoint yourself as trustee in the matter, and you take it in, and now you can move the court in the direction that you want, and that's what you guys are doing right now in Florida. So far, it seems like you're making some headway on that.
Yeah, correct me if I'm wrong, Christian. Wouldn't you want to be the trustee and not make the judge the trustee? That's what I'm asking. That's what I'm trying to get at.
No, not necessarily. I might want to be the beneficiary, and because I've got the trustee who would be the person that's in the breach of the trust.
I know, but remember you said it's kind of like those Russian dolls that are one inside the other, because when you walk in, you are in within at least four different trusts.
Yeah, but
and
like I
really
said before, how do you know
which trust
on with your own knowledge of how you can handle it?
And you have to disseminate which trust you're going to make.
You could win trustee, or you could win by being beneficiary.
Right.
You're in a win-win situation.
Now we just confuse everybody now.
Christian is hitting it right on the head, because you've got duality, you've got triplicate, you've got quadruple. That's why this whole construct of construe and construct can get really screwy. But it's clear that if you plead an express trust, that and you want to define who you are, you're grantor or beneficiary, and that's the way you're going to argue it, or I should say present yourself in the public, go for it. You want to present yourself as grantor or trustor, trustee, go for it.
But I know, but this is a game of chess at very high stakes, and when you think, and I'm sure you've all played chess before, and it looks good when you're making that move, and all of a sudden, boom, he knocks over your queen or whatever, you've got your king, and you're done. That's what I'm saying. You know what I'm saying? It's like,
I know exactly what you're saying, and this is when the light came on this week for me, was that's what the NACRS guys are doing, okay? They're talking all about the express trust. And as soon as you express it, okay, that's the key. If you don't express it, then it's a ping-pong game, and it's a free-for-all, and they're going to do whatever the heck they want, and they're going to have 4, 5, 6 trusts going on at one time,
and your head's going to be going out like a pinball machine. But as soon as you express it and you define the plain rules, the same thing we do with Mickey, exact same thing. When we go in there on the credit cards and we say, does this court respect the court rules? Does this court respect the rules of evidence? Does this court follow the professional conduct? And oh, by the way, is this a court of record? I can get a certified transcript. Bam, now we've got them in contract. We've defined the rules of the game. I don't care what my name is, because we're going to nail them. Because there's no evidence whatsoever that they can bring in with anybody with any first-hand requisite knowledge that a credit card was ever witnessed a signature by the alleged defendant. And therefore, their case falls apart from the get-go. It's the same thing. If we define it up front with the express trust exactly the way Christian's talking about, and it's whatever the comfort level of the individual is going to go in there and argue it, it's either he's going to argue the beneficiary status or he's going to argue under the trustee status. You can win either way, guys. It doesn't matter.
Yeah.
It's it's like martial arts. I mean, I'm in the arts, and I may be 160 pounds. That doesn't mean I can't kick somebody's ass that's 250. In fact, they're easier to take down. All right, so as long as we express the trust, it doesn't matter what we are.
Beneficiary position. This is why I like the beneficiary position. If the beneficiary makes the prima facie case, the burden of contradicting it or showing a defense will then shift to the trustee. The burden of proof issue is one of the most significant distinctions and characteristics about trust law. There is no obvious transition from the threshold burden phase to the substantive burden phase. So where the party claiming trust is the beneficiary, what happens is what is referred to as the shifting of the burden of proof. Thus, where it's the beneficiary who's asserting the trust, then the beneficiary is expected to be the party who files the suit or the claim, because the threshold of the burden of proof is on the beneficiary. Then, once the beneficiary satisfies that threshold burden, the burden of proof shifts to the alleged trustee. And what does the trustee then have the burden to prove? The trustee then has the burden to prove compliance or non-breach. The point to make here about the evidence is that the burden of proof is that once the threshold burden is satisfied, and the law of trust presumes that the trustee is wrong or is guilty or has breached the agreement, that's the power of the trust.
That's the presumption.
The whole thing as it works.
Yes, that's the presumption of the law of trust. That's the law of trust. The trustee must prove that it was consistent with the applicable trust agreement or the indenture by the grantor and with the applicable trust laws. So thus, in a civil or commercial context, the trustee is quite literally presumed guilty or presumed to have breached. As it were, he must prove that it was within the terms of the trust and within the applicable trust law, and that is, he was not guilty. And he can't do that without a proof that he made a payment or disbursement without a record of that. That's what I like about being the beneficiary, because the court of equity is on your side. You are the 900-pound gorilla. That makes so much sense to me now. It really does, because that's the exact, it's the mirror of post-33 equity debtor-creditor. Except when you express it in a trust format as grantor or beneficiary, that makes perfect sense, because the trustee is presumed always guilty. The debtor is the trustee.
Yes, and we always thought that was admiralty. It wasn't admiralty, it was trust.
Mm-hmm.
We always said under creditor and their admiralty, we thought that, you're going into equity and they're going to enforce it. Well, that's not admiralty, that's trust. Here was trust law all the time. It wasn't admiralty. That's how they violate that. Keep you under trust.
And that's when they violate that. The problem is, guys, because I understand what you're saying, but the problem is you have to define the jurisdiction. So if you don't probate the matter, if you get stuck in the equity court or the admiralty court, you're screwed. Because as soon as you claim that beneficiary status, you've got no rights. in that venue. So I'm going back to Roger Elvick's position was probate the matter. It's a gift, probate the matter. And until I get probate, I'm not going to get remedy if I'm playing the role as the beneficiary in equity or admiralty, because you don't have those positions. So it's coming back to jurisdiction or venue. I mean, it's jurisdiction, not venue. This is a great dialogue tonight.
That's why I like the beneficiary position on that. That's to back up the beneficiary. And then, as I said earlier, to back up the trust position, meaning as in equity is that as trustee now, I have the ability to withhold the payment legally because it's a discretionary trust. The beneficiary is insolvent, and therefore I didn't make the payment because if I would have, I would be in breach of trust. I can't breach the trust legally. That's why I didn't make the payment.
So when we walk into a court situation, which trust are we expressing? Do we have to make clear which trust we're expressing?
Yeah, which one are you in court for? That's what I want to express.
Because you said we're walking into 4 different trusts.
Yeah, well, I might want to combine some of them into one and forget maybe one or the other. So I'm only going to be dealing with, say, 1 or 2 trusts.
Christian, this is Marco from Rochester.
Yeah, Mark.
The gentleman who was talking about expressing the jurisdiction. Well, I would like to refer him to the Civil Rules of Procedure, Rule 1 and 2, where they merged equity and admiralty. And then they said there's only one form of action, that's a civil action. So it wouldn't really matter if he went in there as admiralty or anything, basically because they just said that all suits of a civil nature, and whether it's in law, equity, admiralty, so they merged them in Rule 1.
That's what they say, yeah.
Yep. So if they merged them, you start to express.
Now, not on the public side. To get into real equity, you got to go into chambers, and now you got pre-33 equity back where you were.
But so what got you there? They came at you on the public side, but now because you went in and expressed the trust, you go behind the doors, which they'll never let be known. You know, your position, and you bring it into equity. So it doesn't matter how you
that's all confidential anyway. Because I'm going to put a protective order on that, and I'm going to ask that it be sealed, the record be sealed.
That's correct. Now, thing about this, when you put the motion in for the protective order, is there any cases where they have not granted it?
Yeah, there may be some defects on the elements for asking for the protective order. But if that is a major material fact of the case, then if they don't allow me to bring it out forward, then they're violating my due process. Now we've got other problems.
Uh-huh. Yep, okay. So, in a sense, those of us who had used in the past Tim Turner's things and gone into admiralty, well, you can go in and they can't just dismiss it right out of hand because of the fact that they're publicly claiming admiralty, so you can jam them up that way too. So, if you understand the nature of the public and the private, and you're moving back and forth between the two, you can jam these guys up pretty good.
Yeah. We just have to understand the game and how to play tennis. Return the volley back and forth, and know where to the position of the court.
Now, someone was trying to get in earlier when everybody was trying to talk at the same time, and they were mentioning about which trust. How do you go in? Which one of the trusts they said was up to at least 3 or 4 different trusts that you basically are part of? I want you to address that. When we say we're expressing the trust now, I think there's some people here may not understand which trust are we talking about you are expressing that you're going in on an action with.
So, if it's a mortgage foreclosure case, I may incorporate the original trust in that case and treat them as just one. So I combine the two in one.
If you're in a criminal action,
Forget about the one in the one in the county later.
Come again?
I say, forget about the one in the county. We'll play with the one in the county later.
Okay, but now when you're going in on a criminal case and you express the fact that who you are to pay, if you express before then that you are the beneficiary of the trust, okay, and you left it at that, and you appointed that person as a trustee, the judge or the prosecutor as the trustee, and you even give them information saying the fact that, giving them what the fiduciary responsibilities are, what your expectations are. The thing here then is, you're standing as the case being the trust, or the you in the trustee relation, in the beneficiary relationship, in terms of the Constitution of the Declaration of Independence.
Well, I would treat the case as being the trust res, and that's going to be actually the trust, because it's the relationship between the trustee and the trust res and the beneficiary, or grantor's instructions.
But wouldn't that be
it's really a relationship.
Wouldn't that be the same as you express in the trust as your constitutional position as the beneficiary? Because that judge took the oath.
You don't have to put that one in there. I think it's advisable maybe to play with that right now. I don't need to use that big hammer. I'm going to use enough trust powers I need to maybe get my results. If I had to, come back in, I could come back in with the other one, with the Declaration of Independence and stuff.
Well, the hammer I have right now, we talked about this earlier, the hammer I have right now in the case is the fact that the judge put it in writing that he didn't have a duty nor obligation to do the things that by oath he's obligated to do as a judge. I'm not going to mess with that one yet until he doesn't do what he ought to do and let this guy go. If he continues to go on like he
the hammer I would like is that the equity is going to be, as I'm the beneficiary, it's going to be the force that's going to enforce the trustee, because they're assuming that he's already guilty, he's breached the trust, and he's got to prove himself innocent that they didn't.
Matter of fact, I'm telling him, don't argue with me. You said what you had to say. You made him the trustee, okay, and you transferred res to him, the case, you accepted it, you transferred the res, and a certificate of deposit, by the way, saying that what you deposited with him was the various trust documents of 1991 and all that stuff, which is the release of lien and all that. Now, he doesn't do anything with it.
Special deposit.
Yep. And we call it special deposits. I took that the certificate of deposit down there, which is a non-negotiable item, I would assume, because it's not paid to the order off. Right? Okay. So it was a non-negotiable certificate of deposit, transferring the trust res over to the judge, reminding him that since I have not been given the name of a successor trustee, all duties and responsibilities are retained by the original fiduciary, which is him. Handed it to him, and tomorrow morning we go into court again. So I'm going to be sitting in the audience. He don't know what I look like. The power of attorney. And I told the gentleman just to
go around breaching trust.
Yeah, I told him to stand in court. I'm here for the sole purpose of assisting the court in discharging and settling and discharging this matter. And it asked the question: are you not in receipt of the special deposit that's required to deal with this matter, whatever? So don't go pleading. Don't go doing any of that stuff, because right now the judge is the one who's gonna. And not only him, the prosecutor too.
Yeah, they have the duty. Yeah.
So that's the thing for him, is just to sit tight and just wait. Don't argue anything, and don't let them get him into all this back and forth conversation.
But trust if that's what they choose to do by not doing the fiduciary or trustee duty.
Yep. Particularly when they already have
all kinds of damages you can come at them with under equity, where equity is going to say, hey, you breached the trust, you're guilty already. Now, did you make the payment? did you make the disbursement? If not, what are you?
Well, guess what? I went back and looked at the fiduciary contract that we had given the judge before he resigned, called himself resigning. It says that he's liable up to 10 times the amount. That's $20 million. So,
well, there goes his retirement fund.
he just doesn't know it yet. Like I said, my purpose is not to harm the judge, not to destroy the system. Just let my people go, so to speak. No harm, no foul. Because if we go in there trying to tear down the system, we're going to mess up. We're just going to go in there and get justice, trade justice for blood, in other words.
Right, right. So, Chris, were you done? Did you have another question, Chris?
Oh, this is Marco. I'm done.
No, I got a lot of questions. I'll talk to you privately.
All right. Okay, so it's about 12:30, so why don't we call it a night? So.
Another question.
Okay, one more. Go ahead. What's your name?
John, in Indiana. If you're as a trustee, you can appoint a manager for the trust who is has to do. He can't do anything without the trustees. Okay. So if you're going into court as a trustee, you could appoint the judge or whoever as a manager, and he would have to do his duties as per the trustee, right?
Yeah, I could, but I don't know if that would be necessary. I'd want to make him straight trustee and just, allow him to be the one that's, going to be breaching the trust and have equity enforced against him.
Right. That'd be more simple.
Why confuse the issue,
Yeah.
Keep it kind of simple. So the more twists and turns you throw in there, this stuff's got enough twists and turns of its own. Okay, so tomorrow night, the talk show call, and that's at 8 o'clock Eastern Time. That number call-in is 724-444-7444, and the PIN number is 41875#, and I believe you put another £1 after that. So that number again is 724-444-7444, PIN number 8175#, £1. And that's at 8 o'clock Eastern Time tomorrow night on Wednesday. See you that time.
Christian, one quick question. I wanted to send some money to the radio program for Saturday.
Mm-hmm.
How would a person do that?
Look up on the internet there on the realpublicradio.net, and I believe someplace in there there he has a place where the address is where you could send it to Desert.
Oh, okay, all right. Real Public Radio.
Are you talking about giving him a donation, Desert donation?
Yeah, sending him some money. Yeah.
Yeah, I don't know what the address is, but I know it's on therealpublicradio.net on that site.
Okay.
Someplace on there. Yeah.
Okay. All right. Well, thank you.
Okay. All right. We'll see you all tomorrow night, if not Saturday or next Tuesday. So everyone have a great week.
Okay.
All right. Take care.